Hello, welcome once again to Lehto's Law. I'm Steve Lehto. This is not a numbered episode of Lehto's Law. This is episode 1 of Welcome to Crazy Town. And so I'm going to do a series involving a true story that is unfolding in my life right now. I cannot put this video up for a little while though because I want the story to end so I can actually end the story arc. And you'll understand why as I tell you the story because I don't know how it's going to end. But I'm going to do the videos now because I think the story is fresher in my mind. Plus, I'm a little more fired up about it right now. So here's the deal. Episode 1, Welcome to Crazy Town. A couple weeks ago, a friend of mine texted me and said, Steve, someone right now is trying to serve you with a summons and complaint. A process server is looking for you. And I said, what are you talking about? I'm an attorney. I do sue people all the time. I sue people for fun, as I often jokingly say. But who'd be trying to sue me right now? Now, I've been sued a couple times in my adult life, and we'll get to that later. But who's trying to sue me? And he goes, well, I don't know. Process server wouldn't say. I said, well, did you just give him my phone number and tell him to call me? And he goes, yeah, I did. I said, okay, cool. I'm not that hard to find. If you want to serve me with process, call me. I'll take it. I don't care. I'll fight you in court. I'm not going to fight in the hallway of an office building, you know? So process server called me that evening and said, yeah, I've got a summons and complaint for you. And I go, okay. I go, do you know where my office is? He goes, yeah. I go, I'll meet you there tomorrow morning at 9 a.m. I go, is there some reason why you didn't just serve me there already? He goes, well, I don't know, mumble some nonsense. And I said, 9 a.m. tomorrow morning, meet me in my office, and I'll be there. He goes, okay. So 9 a.m., guy comes walking in. He has a summons and complaint. I go, is that for me? And he goes, are you Steve Lehto? I go, yeah. And he goes, okay, and he hands it to me. And on the back of every summons that you get in the state of Michigan, if you do it right, it's a two-sided piece of paper, but these idiots didn't do it right. But there's a thing down here called acknowledgement of service. I even signed a document saying I acknowledge the service. I got the service. I'm not dodging service. I'm one of the easiest people on earth to find. I'm very easy to find. So I said, okay, cool. I said, thank you. So I look at it, and because who is suing me? I'm curious about this. I haven't wronged anybody. And here's the interesting thing: the summons and complaint. Summons. Plaintiff's name: Marv's Tire and Wheel Inc. et al., meaning and others. Defendant's name: Lehto, Steve, which by the way is not even my legal name. I've discussed that before. But hey, my professional name is Steve Lehto, so I'll go with that. Plaintiff's attorney, and it lists a plaintiff attorney who has an office in Southfield. And this is going to be important for a later fact, but her office is about a mile from my office, maybe 2 miles away. Okay, so about 2 miles from her office to my office. Okay, remember, her process server had a hard time finding me. And I'm looking at this lawsuit because I recognize the name Marv's Tire and Wheel. Marv's Tire and Wheel is a company that I sued on behalf of a client of mine 7 or 8 years ago. Quite a while ago. So I'm going, well, now why would Marv's Tire and Wheel be suing me when I sued them on behalf of a client of mine 7 or 8 years ago? It's kind of weird. But the good news is there's a lawsuit here. And so I can just read the lawsuit and see what it is that they're claiming that I have done wrong, because I must have done something wrong, because they are in fact suing me. So I looked at this and I said, okay, cool, whatever, it's a lawsuit. I got served. I got 21 days to file an answer because it's hand served. So I'm looking at this going, okay, let's take a look at this lawsuit. Now the interesting thing is the lawsuit's right here. And the first thing I noticed is the lawsuit is voluminous. It is apparently a 56-page document. There's page 56. In my entire career, I've never filed a 56-page complaint against anybody. So this is somebody who's doing some very creative drafting and having very little respect for the life of trees. Something that's where most paper comes from. And it says Marv's Tire and Wheel Inc. Plaintiffs versus, and it lists a whole bunch of people, and I'm among the bunch of people it names, but it also names my former client, the guy I sued Marv on behalf of. And then I noticed they've named a sheriff's deputy who helped me execute service, named another sheriff's deputy, and an attorney I worked with on the case, and someone else whose name I don't recognize. And so the upshot of this complaint is apparently I filed a lawsuit on behalf of my client against Marv's Tire and Wheel 7 or 8 years ago. We got a judgment against Marv's Tire and Wheel. Marv didn't pay the judgment. And so we sent in some sheriff's deputies with a writ of execution. They executed on Marv's Tire and Wheel. They got money from Marv's Tire and Wheel to satisfy the judgment, and then everyone went their way. 6 years ago. So this lawsuit now says that plaintiff, and by the way, it's a first amended complaint, implying that there's a previous complaint no one told me about. And then I noticed, of course, that the case caption has a case number starting with 18, meaning that this case was filed a year ago, because this is 2019. And so the case was filed in 2018, there's a problem. And sure enough, I looked it up on the Wayne County Circuit Court docket entry listing on the computer, on the internet, and in fact, this lawsuit was filed last year. So somehow it took this woman and her process server more than 9 months to serve me, despite the fact my office is 2 miles from her office. But she says that her client is a corporation and a resident of Detroit, and lists a bunch of people and says, upon information and belief, defendant Steve Lehto is an attorney, licensed to practice law in the state of Michigan. That's true. But now let's try to figure out what's going on here. Why am I being sued when all I did was sue somebody else and get a judgment that was valid, and then we had it executed on, which is, by the way, something that happens every single day across America and happens every single day in Wayne County. And has happened on many of my cases where I had to get judgments against people. And then when they didn't pay, I sent out sheriff's deputies to execute on the judgments. And the sheriff's deputies, in case you're curious, are court officers, badges, guns, deputized, the whole shooting match. This is as legal as it gets. So it says here, general allegations that there was a, and I'm not making this up, writ ripoff, bailiffs in quotation marks, conspire to abuse court system, misrepresent writ to convert small business owners' property. And it says that in January of 2012, the 36th District Court issued a judgment in favor of my client, which is true. Which, of course, you don't need to do much math on this. That was 7.5 years ago. 7.5 years ago. Over 5 years have passed since entry of the judgment. Well, that's true also. And then it says that plaintiff runs a small, closely held auto supply company with his wife. That may or may not be true, and I really don't care. It says defendant, my former client, claimed that plaintiff had improperly installed wheels on his car, which is true. The wheels fell off and caused damage, which is also true. And by the way, all of this was litigated in the 36th District Court 6 or 7 years ago. And then it says here that back in 2012, the defendants filed an ex parte motion for leave to grant a court officer authority to seize property. That's probably true. We did, in fact, get a writ to seize property. And then it says here the bailiff bamboozled Marv's Tire and Wheel. And again, a rip-off and a bamboozle, those are not actual legal terms. An attorney shouldn't write things like that in a complaint. But it says here that in January of 2013, again, more than 6 years ago, defendants arrived at plaintiff's place of business, presented themselves as bailiffs. The two men represented the plaintiffs that they were there to collect a judgment, and plaintiff was unaware that an order to seize property had been issued. What's amazing about this story is this guy apparently went in and found an attorney and just told her a story, and she didn't check any of it. And I've done videos recently about how attorneys are supposed to investigate facts and come to good faith belief that everything they file is grounded in fact and law. And all she had to do is determine, by going through the court file, that this guy had 2 or 3 different attorneys in the district court who tried arguing all of these things in the lower court, and they lost all these arguments. The guy was represented by counsel. I can think of the 2 names off the top of my head. May have been 3, or at least maybe this woman here's the 3rd. But the point is that all of these arguments were made in the lower court, and they were all losing arguments. So anyways, afterwards, they did seize a bunch of property, a bunch of cars, and a Jaguar wheels and tires and chrome wheels and a shotgun and a DeWalt table saw. And of course, these things all were seized and sold at auction pursuant to a writ of execution, which allows a court officer to do those things. But according to this crazy attorney who filed this, the phantom execution and the actual hidden sale, these things were all sold at public auction. We have notices for all the public auction notices. The notices were all sent out. I've got copies of them still. I actually found them. And they're complaining that these auctions took place, but somehow, since her client didn't hear about it or didn't show up, that's a problem. But anyways, the upshot is this. The guy lost in the district court. A judgment was entered against him. He didn't respond to that. He didn't pay it. Court officers came out and executed on his property, took all his property to auction, and sold it. He's now claiming that he shouldn't have lost in the lower court. No one should have seized his property. The judgment was improper, and now he wants all his stuff back and all his money back. And of course, if he had wanted to, he could have appealed the judgment in the 36th District Court, which he didn't do. He could have sought to have it set aside, which he did do. He tried getting it set aside. And apparently that effort failed in the end. And then he waits 6 years and talks his attorney into filing this action. So, count 1, tortious interference with a business prospective economic advantage. Count 2, civil conspiracy. Count 3, abuse of process. Count 4, conversion. But I'll just, for comic purposes, tell you, plaintiffs request that this court enter judgment against defendants. I'm one of the defendants. In the amount of $200,000 plus treble damages pursuant to MCL 629-19A, along with costs, attorney fees, and all other relief this court deems just and proper. So this crazy attorney thinks that I owe her client $600,000 because her client lost in court and ignored all kinds of legal actions. Count 6, negligent infliction of emotional distress. It's not even a cause of action in Michigan. Count 7, negligence. Count 8, claim and delivery. And by the way, they're filing a claim and delivery action to try to undo a sheriff's sale. It's the one place you cannot do a claim and delivery action in the state of Michigan. Claim and delivery on the Porsche, can't do that either. Claim and delivery on the Riviera, can't do that. Claim and delivery on the van, can't do that. Count 12, claim and delivery on a welder, can't do that. Count 13, claim and delivery on some wheels, can't do that. Count 14, and there's literally count after count after count, and it's all these claim and delivery actions where they're saying that they want the court to order people to give stuff back that was sold pursuant to a sheriff's auction. And Michigan court rules and the Michigan law says if you bring a claim and delivery action, the one thing you cannot do is try to get something back from a sheriff's auction. Otherwise, every single person out there who lost stuff to an execution would file a claim and delivery action and clog the courts up. And also, nobody would ever go to a sheriff's auction and actually bid on anything, knowing that a claim and delivery action would be coming down the road, and they'd have to fight that off. So, anyways, I'm just jumping to the end here. Count 29, claim and delivery, antique shotgun. Count 30, fraud and misrepresentation. Count 31, silent fraud. Count 32, Michigan Consumer Protection Act. Now, this is insanity. I'm a specialist in the Consumer Protection Act. I'm one of the 3 attorneys in the state who actually knows it. And according to this, defendants made substantial misrepresentations of fact regarding the writ of seizure. The problem, of course, is that we aren't merchants. Her client is a merchant, but the Consumer Protection Act doesn't protect merchants against attorneys. It protects consumers from merchants. So this is backwards, it's inside out, it's insanity. Count 33, concert of action. It's not really cause of action, but we won't get into that. Count 34, violation of the Fair Debt Collection Practices Act. She's insane. Count 35, violation of the Michigan Collection Practices Act. Again, doesn't apply here. And then unjust enrichment. And of course, she does have the complaint signed by her client, Marvin Flowers, because he's willing to sign a piece of paper and say, hey, I think this is all good. I want my stuff back. So what we have here is, like I said, like a 30-some-odd count complaint, 56 pages long. I had to hire an attorney. Now, you might say, Steve, you're an attorney. Defend yourself. Well, there's an old saying about attorneys represent themselves, have fools for clients. And that's true. And number 2, I don't do a lot of defense work. And I know people who do. And I'm smart enough to know that I know what I know, and I know what I don't know. And so I went and contacted a good buddy of mine named Ed. I sat down with Ed. I go, dude, here's the story. Told him the whole story. I said, will you represent me? He said, absolutely. And unfortunately, all these other people had to hire attorneys. A couple of them hired my guy, but a few of them hired their own attorneys. And so we had to file an answer to this pile of garbage. And the interesting thing is that in Michigan, there are a variety of defenses you can raise to something. Okay? And I have hinted all along now that all of these actions that are mentioned in this complaint took place more than 6 years ago. More than 6 years ago. And most people, regardless of how much they know about the legal system, have heard the phrase statute of limitations. And in a criminal setting, you've heard there's a statute of limitations, and if you commit a crime, there's only so many years within which they can arrest you, except if it's a murder claim. Most states have got no statute on murder. And the same is true with a civil claim. So for instance, in Michigan, if you have a contract action with somebody and they breach the contract, you get 6 years to file the claim. 6 years is pretty much the longest of any statute of limitations you're going to find in Michigan. And so the fact that everything in this complaint happened more than 6 years ago is a very, very serious problem in the pleadings, right? There's other problems as well. And again, I did a video very recently where I talked about how the ethical rules in Michigan as well as the court rules in Michigan say that an attorney who signs her name to something is telling the court that she's read it and she believes it to be factually well-grounded and she's done an investigation and it's well-grounded in law, okay? So the question becomes, if you do the most basic investigation into this case, a guy comes into your office and says, hey, look, I had all my stuff stolen from me. I want it back. When did this happen? More than 6 years ago. How did it happen? Well, these guys sued me. I didn't answer the complaint. They defaulted me. They got a judgment against me, which I ignored. I did have a couple of attorneys go into court and try to get it set aside, but it kind of spun our wheels. Nothing really became of that. And in the end, they got a writ of execution against me. They took a bunch of stuff pursuant to the writ, and they sold it at a sheriff's auction more than 6 years ago. The attorney should have just said, oh, based on what you've told me, you have no case. You have no case. What you just described to me is not a case. But instead, she sat down with him and drafted a 56-page, 35-count complaint of gibberish, filed it in December of 2018, and then spent 9 months deciding that she was going to serve me, despite the fact my office is 2 miles from her. She could have thrown it out the window in December. I would have gotten it faster. Okay? So I'm going to end now because I'm running out of time. So this is the end and conclusion of Chapter 1 of Welcome to Crazy Town, because I just got dragged to Crazy Town by an unethical attorney, and I will do follow-ups to this story as it progresses, and hopefully when the story ends, I can have a nice conclusion and wrap it all up with a bow. But as of right now, I don't know what's going to happen. Neither do you. So we can enjoy the journey together. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.